The United States Supreme Court has just dropped an emergency ruling that is sending shockwaves through legal circles, election officials, and constitutional scholars across the entire country. In a high-stakes showdown over congressional redistricting and voting rules ahead of the 2026 midterms, the justices stepped in at the last minute, granted an emergency stay, completely overriding a lower court's aggressive injunction, and restored the exact election maps and procedures that states like Texas, Alabama, Louisiana, and others had carefully drawn and wanted to use. But here's the thing. The real story is not simply that the Supreme Court intervened. The real earthquake is why the court intervened, what the justices said about the authority of lower federal courts, and how this emergency ruling could permanently redefine the balance of power between states and federal judges when it comes to administering elections, because buried inside this emergency order are signals that suggest something much larger is unfolding, signals that could influence future disputes involving voter regulations, redistricting battles, ballot access, and the growing constitutional conflict between state governments and federal courts. And right now, legal experts across the country are asking the same question. Is this merely an emergency procedural ruling, or is the Supreme Court quietly laying the foundation for a much broader transformation in American election law? To understand how we got to this explosive moment, you have to understand the growing tension that has been developing between state governments and federal courts over the administration of elections. For years, election law has become one of the most heavily litigated areas of constitutional law in the United States. Nearly every election cycle brings new lawsuits, challenges over voter identification requirements, challenges involving absentee ballots, challenges involving district maps, challenges involving voter registration procedures, and increasingly, many of these cases end up before federal judges who are not elected by anyone and who answer to no voter. Supporters of federal intervention argue that courts serve as an essential safeguard against constitutional violations and protect voting rights from unlawful restrictions. Critics, however, argue that federal courts have become too willing to insert themselves into election administration and far too comfortable overriding decisions that state legislatures are constitutionally authorized to make. That debate has been intensifying for years, and now the Supreme Court appears increasingly willing to draw clear lines around where those boundaries actually exist. This latest emergency ruling emerged from a dispute that had already generated significant controversy at the lower court level. Following the Supreme Court's recent landmark rulings on redistricting and the Voting Rights Act, several federal district courts were supposed to apply stricter standards. They were supposed to separate race from politics, respect traditional redistricting principles like compactness and communities of interest, and give state legislatures the presumption of good faith when drawing their own maps. But in key states, activist lower court judges essentially rebelled. They issued injunctions blocking lawfully enacted state maps, forced the use of court-drawn alternatives that often favored one political side, and did so right in the middle of candidate filing periods and active election preparations. Take the situation in a major southern state as the prime example that triggered this emergency appeal. A 3-judge panel blocked the state's congressional map, claiming it violated Section 2 of the Voting Rights Act through alleged vote dilution. Instead of allowing the legislature's map to stand, they imposed a special master plan that radically altered district lines, pairing incumbents in ways the legislature never intended and disrupting long-standing communities of interest. This was not a minor tweak. This was a full-scale judicial takeover of the state's sovereign authority to manage its own elections. The state immediately filed an emergency application for a stay with the Supreme Court, and the justices moved quickly and decisively. After reviewing the arguments, the court granted emergency relief, blocking enforcement of the lower court's order and restoring the state's preferred map while litigation continues. But the significance of the ruling goes much deeper than the procedural outcome. The language used by the court immediately caught the attention of legal observers nationwide. The majority strongly suggested that the lower courts had exceeded their proper role. The justices emphasized that election administration remains primarily the responsibility of state governments. They highlighted serious concerns about federal judicial intervention occurring during active election preparations, and in doing so, they may have provided a roadmap for how future election disputes will be evaluated moving forward. Now let's break down exactly how the Supreme Court dismantled the lower court's reasoning point by point, because this is where the ruling becomes truly significant. First, the justices reaffirmed the strong presumption of legislative good faith. The lower court had treated the state's continued defense of its map as evidence of discriminatory intent. The Supreme Court called this approach legally backwards. State legislators, elected by the people, are entitled to that presumption when exercising their core sovereign function of drawing districts. You cannot simply assume bad faith, because the outcome does not match what plaintiffs or judges prefer politically. By flipping this presumption on its head, the district court had effectively shifted the burden of proof in a way that undermined the entire constitutional structure of federalism. The Supreme Court forcefully reminded everyone that disagreement with a court order is not the same thing as racial animus. Second, the court hammered the lower court for botching the application of recent redistricting precedents. Under the clarified framework established in recent landmark decisions, challengers cannot simply demand a map that maximizes minority voting strength while ignoring everything else. Their alternative maps must perform comparably across legitimate, traditional redistricting criteria, things like respecting county lines, keeping communities together, avoiding unnecessary incumbent pairings, and maintaining compactness. The plaintiff's proposed map failed on multiple fronts. It ignored critical communities of interest along the Gulf Coast, where economic, cultural, and historical ties bind voters together. It created bizarrely shaped districts that split counties unnecessarily. The lower court ignored these failures entirely, essentially substituting its own policy preferences for the reasoned judgment of elected state representatives. Third, and perhaps most important for the nationwide implications, the Supreme Court invoked and reinforced the Purcell Doctrine. This is the vital principle that federal courts should not be making last-minute changes to election rules close to an election. The district court had tried to justify keeping their special master map in place by claiming it was more convenient for election officials already implementing it. The Supreme Court rejected that argument completely. They reaffirmed that while judges must avoid creating chaos, sovereign states retain the primary authority to decide how to administer their own elections. Restoring the legislature's map was not chaos, it was correcting judicial overreach. States are free to make adjustments they deem necessary without being held hostage by federal injunctions. As expected, the liberal justices were not pleased. Justice Sotomayor authored a sharp dissent, joined by Justices Kagan and Jackson. She warned that the ruling would force hundreds of thousands of voters into new districts with little notice, accused the majority of enabling state gamesmanship, and argued that the decision undermines the Voting Rights Act. The dissenters expressed concern that the majority placed too much weight on election timing and not enough weight on the underlying constitutional claims being litigated. From their perspective, protecting constitutional rights remains essential regardless of administrative inconvenience. But the majority's response was clear. The real threat to election integrity comes from unelected federal judges usurping the role of state legislatures, not from returning power to the people's elected representatives. When election rules change at the last minute through judicial decree, confusion follows. Election officials must scramble to adjust procedures. Candidates alter campaign strategies. Voters become uncertain about the rules governing the process. The Supreme Court has repeatedly warned about these dangers, and in this ruling, the majority appeared determined to reinforce that message with unmistakable force. Right now, on the ground, the impact of this ruling is immediate and tangible. In the affected states, election officials have wasted no time. They are rapidly reconfiguring district boundaries back to the legislative maps, updating voter rolls, recalibrating ballot printing, and communicating changes to candidates and county clerks. Political campaigns that had been operating under the court-imposed map are now adjusting strategies. Some incumbents who were forced into unfavorable matchups are breathing easier. This restoration brings much-needed certainty as candidate filing deadlines approach and the 2026 midterm cycle intensifies. Beyond the immediate parties, this decision is rippling across the country in ways that will matter for years. Multiple states facing similar redistricting challenges are watching closely. Attorneys general in several Republican-led states have already signaled they may seek similar emergency relief if lower courts attempt the same kind of defiance. Legal experts on both sides agree this ruling strengthens the hand of state legislatures significantly. Consider the broader impact on the Voting Rights Act specifically. For years, Section 2 has been stretched by some litigants and courts into a tool for proportional racial representation rather than a genuine shield against discrimination. This ruling, building on recent Supreme Court precedent, reinforces that states have wide latitude to draw maps based on traditional race-neutral principles. Challengers will now face a much higher bar. They must present compelling alternative maps that respect communities of interest, compactness, and political boundaries. Not simply maps that deliver more favorable partisan or racial outcomes. This shift protects states from being forced into racial gerrymandering that itself risks constitutional violations under the Equal Protection Clause. The ripple effects are already being felt in battleground states facing similar lawsuits. States like Georgia, Florida, and South Carolina are studying this opinion closely. Some have ongoing cases where lower courts have issued injunctions. They are now far better positioned to seek emergency stays with significantly stronger odds of success. Even in states without active litigation, this decision strengthens the hand of legislatures as they prepare for post-2030 census redistricting cycles. But what makes this ruling particularly fascinating to constitutional scholars is not just the immediate outcome. It is what it may reveal about the Supreme Court's broader direction. When you step back and look at the larger picture, a clear pattern begins to emerge. Over recent terms, the justices have repeatedly found themselves at the center of major election disputes, and each time, the court has placed increasing emphasis on the same core themes: judicial restraint, state autonomy, institutional limits, the proper boundaries of federal court power. Taken together, these themes suggest something more than a single emergency ruling. They may indicate an emerging constitutional framework, a framework that prioritizes the role of elected state officials over federal judicial intervention, a framework that asks courts to intervene only when absolutely necessary and firmly grounded in clear legal violations, and a framework that gives states the breathing room to administer elections without constant fear of being overruled by unelected judges. This ruling also fits into a broader, unmistakable trend we have seen at the court in recent months. The justices have protected voter ID and procedural safeguards in other election cases and repeatedly emphasized limits on federal judicial power in election administration. The court is systematically building a legal architecture that prioritizes federalism, textualism, and restraint. They are drawing clearer lines around when federal courts can intervene and when they must defer to the people's elected representatives. For the 2026 midterm elections specifically, this ruling delivers much-needed stability. Candidates, parties, and voters can now operate under clearer and more predictable rules. Election administrators gain breathing room to implement legislative maps properly without court-mandated confusion arriving at the last minute. And most importantly, voters benefit from districts drawn by their elected representatives rather than unelected special masters. One of the most significant long-term effects may be deterrence. Federal district courts and other jurisdictions that were considering similar aggressive interventions against state maps are now on notice. Judges who previously felt emboldened to impose their own preferred maps or special master plans must now think twice. The Supreme Court has shown it will step in quickly via emergency relief when lower courts ignore precedent and disrupt election timelines. This alone could reduce the flood of frantic, last-minute redistricting litigation that has plagued recent election cycles. For everyday Americans, this matters because fair elections are the foundation of self-government. When state legislatures, accountable to actual voters, can draw maps without constant judicial interference, it strengthens representative democracy. When federal courts are restrained from micromanaging every district line or procedural rule, it prevents the kind of judicial overreach that erodes public trust in the entire system. Of course, this will not end all controversy. Liberal justices and advocacy groups will continue to push back, filing new challenges and arguing that states are engaging in voter suppression or unlawful dilution. Expect more dissents warning of chaos and gamesmanship, but the majority's repeated emphasis on the presumption of legislative good faith, the Purcell Doctrine, and the proper application of the Voting Rights Act creates durable guardrails that will be very difficult for lower courts to ignore going forward. Because this emergency ruling does not exist in isolation. It arrives at a moment when numerous election disputes are already moving through the federal courts. Some involve voter access, others involve election administration. Others involve redistricting and representation. Many raise questions remarkably similar to the ones addressed here, which means the Supreme Court may soon face additional opportunities to clarify and cement its position with a full merits decision. And if that full decision follows the direction so clearly signaled in this emergency stay, the consequences could stretch far beyond any single dispute. Future attorneys will cite this ruling. Future judges will analyze its reasoning. Future litigants will build arguments around the principles it establishes. And future election battles may be decided in part because of what was said here. That is how precedent works at the highest level. A single ruling becomes the foundation for dozens of future cases. And when the Supreme Court speaks this clearly in an emergency posture, everyone listening understands that the court's guidance today will shape legal outcomes for years to come. That is how precedent works at the highest level. A single ruling becomes the foundation for dozens of future cases. And when the Supreme Court speaks this clearly in an emergency posture, everyone listening understands that the court's guidance today will shape legal outcomes for years to come. What separates this moment from prior legal skirmishes is the combination of urgency and clarity. The Supreme Court did not simply pause the lower court's order and walk away. They explained their reasoning in detail. They identified specific legal errors. They named the doctrines being violated. And they did all of that in an emergency posture, which means they felt strongly enough about the underlying issues to act fast and explain themselves thoroughly rather than waiting for full briefing and oral argument. That level of engagement in an emergency context is unusual. Legal scholars pay very close attention when the court operates that way, because in several past cases, the language used in granting a stay proved nearly identical to the language used months later in the final opinion. If that pattern holds here, the states defending their maps should feel very confident about where this is ultimately headed. The emergency ruling itself may have resolved one immediate dispute, but it has also raised larger questions that remain very much alive. Questions about authority, questions about constitutional interpretation, questions about the proper limits of judicial power, and questions about whether the era of aggressive federal judicial management of state election systems is drawing to a close. Those questions are not going away. The next major case could arrive at the Supreme Court sooner than anyone expects. Another emergency application, another lower court decision that pushes boundaries, another constitutional confrontation that forces the justices to clarify what they meant today. And when that moment arrives, every word of this emergency ruling will be examined carefully by attorneys, judges, and lawmakers on every side of the debate. The Supreme Court has spoken. The lower court's overreach has been corrected. State authority has received powerful constitutional support, and the national debate over election law has entered a new and consequential chapter. What happens next may prove even more important than what we witnessed today, because the legal battles now moving through federal courts could determine how elections are administered across the United States for an entire generation. And if the direction of this court is any indication, those battles are heading toward a reckoning that will reshape election law in ways this country has not seen in decades.